The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show. So right there you have the information for Ray Fowler, our guest today. And there, every week, Don Moore and Dan Moore, the Moore Law Firm, moorelaw.com. You can get all the information at fox19.com by clicking on Moore Law. We're back for just a few more minutes, and you wanted to make sure to give the viewers some information about domestic violence.
Yeah, I did, because, Deb, thank you. That's one of the more common charges. I know the Public Defender's Office sees that quite frequently, and oftentimes people who don't have criminal contact do. And I thought it would be good for people to know. Number one, generally there's going to be an arrest. So if someone picks up the phone and calls 911 and says that they've been hit in their home, there's going to be an arrest. Somebody's going to go to jail. Number two, if you're convicted, it's a $1,000 fine, 6 months in jail. Those are the maxes. Excuse me, for a first offense, and a temporary restraining order can be immediately put into effect, which means the individual who was arrested, if they post bail, are not going to be allowed back in the house. Now, the difference between domestic violence and just a straight assault is you live in the same house. So what is domestic violence? One of the things that when I've spoken to groups, especially young people, I'll ask them, how many of you have a brother or a sister? How many of you have pushed or hit your brother or sister at some point in time? And about all of them raise their hand. Well, I tell them then they're all guilty of domestic violence. They just haven't been charged and convicted. It's real easy to slip into this for people who aren't really criminals or desperados, but they get carried away in an argument, and it can become serious business very quick once the government involved. Ray, what's the frequency of domestic violence cases as far as the public defender's office? Is that a large part?
We have a fair share of them, like any attorneys, practicing attorneys do. We have a lot of those cases, and they're serious cases. The consequences are serious, because if you're convicted of domestic violence as a first-degree misdemeanor, and now there's two kinds, a first-degree and a third-degree misdemeanor, but the more serious one, if you're convicted of that, that can never be expunged in Ohio the way the law is written now. The first degree is for causing or attempting to cause physical harm. The fourth degree is for threatening harm. It's more like or the third degree, it's more like a menacing charge.
So like attempting to cause physical harm, somebody picks up their shoe and throws it at the person, they could conceivably be, even if they didn't hit them, they could be convicted of a first-degree misdemeanor that could never be erased from their record.
That's right.
Okay.
That's right.
Well, Ray, this brings up something that we chatted about a little bit before. That's such a, unfortunately, domestic violence can be a he said, she said. What happened in that, those two people really are the ones who know. So if somebody in your office is defending somebody, in any case, whether it's domestic violence, and they really believe they're guilty, how do they defend them and enter these not guilty pleas and try to help them escape the punishment?
Well, Deb, first of all, everybody's presumed to be innocent when they come into a courtroom. Secondly, our attorneys weren't there. If they were there when the incident occurred, they'd be witnesses. They wouldn't be the attorneys in the case. Now, sometimes a client will tell you, yes, I did all these things, and sometimes all a lawyer can do is cut their losses, mitigate their punishment. They might say, yes, I did this. I threw a shoe, but it wasn't that bad of a deal. Can we work this out to a less serious charge? Sometimes that's all an attorney can do for a client. Other times a client says, I want to go to trial. You can defend anybody, you just can't suborn perjury. You can't put your client on the stand knowing that that client's going to lie about what happened after they told you something different. But you have every right to challenge the state's evidence to test their case.
Okay.
And part of the case testing, that's part of, I guess, a person's right, or when it's ethical, actually, when a person says maybe they've committed the crime, but the state's missing some element or something, and then it's okay to plead them not guilty. Is that right?
Well, if the state's missing an element, they're not guilty of that crime.
Okay.
So you have the right to go to trial. That's your constitutional right.
One of the things you also, I think, is just fascinating, and I think other people are interested in it too. Basically, the law says you're presumed innocent from the time you go in until the time you're convicted. But reality is, every juror, every judge, every policeman, everybody in there assumed you did something or you wouldn't be there. Isn't that true?
Sure. Everybody thinks you must have done something or you wouldn't be here. That's right.
So the defense lawyer's kind of got an uphill battle, doesn't he?
Well, but your defense lawyer is maybe your only friend in the courtroom. It's very important to be truthful with your attorney and work with your attorney.
Okay. All right. Let's see. Let's go to Ronald in Cincinnati. Ronald, you had a question about a felony you received.
Yes. I have a felony that I had. It's called inciting to violence, and it's back in '85 that I had the case, and I think it was like 7 years after that, try to expunge it. And is there any way it still get expunged and it's been over like 20 years, I guess?
Well, it depends. Do you have any other convictions?
No, that's the only felony I had when I was a teenager.
Okay, and what level offense was it at that time? Do you know what level felony?
I think it was 4.
Well, you should be able to expunge a 4th-degree felony. It might be that you filed too soon. You have to wait 3 years after a case is over, and if you're on probation for 5 years, that's really 8 years from the date of your conviction. It's 5 years of probation, then 3 years after the felony, after you got off that probation. So you probably would be a good idea to talk to an attorney, bring all the facts, and see if you're eligible. You might still be eligible. It might just be that you didn't wait long enough to get it expunged. But if you have another conviction, if you have a DUI conviction out there somewhere or something else that you said, well, I didn't go to prison for, that doesn't mean you might not have another conviction. Sometimes that's how people look at things. If I didn't go to prison, I didn't get convicted. But the judge could not legally expunge that if you had another conviction. But that's changed now. 1 felony and 1 misdemeanor can be expunged in Ohio. So it's worth taking a look at.
And Ray, we have just about a minute left, but I know there was something you wanted to say to folks at home, that if I am charged with something and I didn't do it, or I think I can handle it, should I try to do this on my own?
Never, never, never. Unless you know what you're doing, you're just asking for trouble. And I told you before, in my whole career, whenever I've seen a police officer in trouble or accused of some wrongdoing, the first thing the officer says is, I want my FOP lawyer here. I'm not going to talk to the other police making an accusation or investigating that officer.
So if the police know to get to talk to somebody.
So should you.
That's a big clue.
So should you.
That's a big clue.
Right.
Absolutely.
All
So,
right.
so should every lawyer in town.
Well, Ray Fowler, thanks for joining us today.
Yeah, thanks a lot
you.
for coming,
Thank you for
Ray.
having me. I appreciate being here.
All right, and next week we'll be talking about traffic accidents.
Yeah, we will. And you know, one of the things I thought was especially interesting was where the car ran into the lake and a kid was killed. How do you present a coverage for that?
Yeah, I don't know. We'll talk to you. We'll see you about it next week on More Law next Monday morning.